The moving van had barely pulled away, its diesel rumble fading into the humid September air. When I first laid eyes on her, I was standing on my new front lawn, a patch of impossibly green grass in the heart of Maple Creek Estates, feeling a sense of profound, bone-deep relief. For 35 years, my life had been a maelstrom of conflict, of arguments parsed, and lives weighed in the balance. My career had been a long, slow climb to a place of sterile, mahogany-paneled authority, a place I had finally, gratefully, left behind. All I wanted now was the quiet hum of a lawnmower, the scent of my wife's roses, and the blissful anonymity of being just another guy in a beige house, on a street with an overly quaint name. My wife, Elena, was the architect of this new life. She emerged from the front door, her face smudged with dust but beaming, carrying 2 tall glasses of iced tea. "To peace and quiet," she said, her voice a melody against the backdrop of chirping crickets. We clinked glasses. The ice cubes chimed like tiny bells of freedom. "To us," I replied, squeezing her hand. "No more motions. No more appeals. No more—" "Mrs. Peterson," a sharp, clipped voice cut through our moment. We turned. Standing on the pristine sidewalk was a woman who seemed to have been assembled from a kit labeled suburban authority figure. She was in her late 50s, with a helmet of blonde hair that looked entirely immovable, even in a stiff breeze. She wore a pastel pink pantsuit that was ruthlessly starched, and in her hand, she held the instrument of her power, a clipboard. "I am Carol Peterson," she announced, her eyes flicking from me to Elena, then down to a small, cheerful object near Elena's nascent flower bed. "President of the Maple Creek Homeowners Association." She didn't offer a hand or a smile. Her expression was one of pained duty, as if she were a health inspector who had just discovered a colony of rats. "Arthur Davies," I said, offering a neighborly smile that felt foreign on my face after so many years of judicial neutrality. "And this is my wife, Elena. A pleasure to meet you. We just moved in." Carol's gaze remained fixed on the flower bed. "I can see that," she said, her eyes, small and hard, narrowed. "Which is why I feel it's my duty to get you started on the right foot, before bad habits set in." She took a deliberate step onto our lawn, my lawn, and pointed a perfectly manicured finger at the source of her consternation. "That," she declared, her voice filled with the gravity of a prosecutor revealing Exhibit A, "is a violation." I followed her finger. There, nestled amongst the freshly turned soil where Elena planned to plant her peonies, was a small, ceramic garden gnome. It was a whimsical little thing, with a pointy red hat, a long white beard, and a fishing rod in its hand. A housewarming gift from our daughter. A silly little joke. Elena's smile faltered. "The gnome. What's wrong with it?" Carol sighed, a theatrical exhalation of profound disappointment. "Bylaw, 17 Section C, subsection 4. She recited as if from scripture. "All lawn and garden ornamentation must be submitted for prior approval to the Architectural Review Committee. Unapproved statuary, figurines, or effigies of a whimsical or folkloric nature are strictly prohibited." She tapped her clipboard with a sharp thwack. "This would be classified as whimsical or folkloric." I stared at her, then at the gnome, then back at her. I had spent decades presiding over cases involving racketeering, interstate trafficking, and complex financial fraud. Now, I was being confronted with an illegal gnome. The absurdity of it was so potent, it was almost dizzying. My mind, a creature of habit, automatically began to analyze her statement. She's not offering a warning. She's reading a charge. She cites the specific statute. This isn't a negotiation. It's a sentencing. It's just a little garden gnome, Elena said, her tone a mixture of disbelief and irritation. The rules are the rules, Carol countered, her voice hardening. They are what protect our property values. They are what separate Maple Creek from other places. She said other places, as if it were a contagion. We pride ourselves on a uniform, aesthetically pleasing community. That gnome is an eyesore. It lowers the tone. I could see the spark in Elena's eyes, the one that always appeared when she encountered willful, gratuitous stupidity. I stepped in front of her slightly, a habit from a lifetime of de-escalation. Well, Mrs. Peterson, I began, using my most reasonable, conciliatory tone, a tone I had perfected over years of addressing agitated juries and volatile defendants. We apologize. We haven't had a chance to read through all the bylaws yet. We'll be sure to rectify the situation. Carol's thin lips pressed into a line of grim satisfaction. I'll give you 24 hours to remove it. After that, an official written warning will be issued, followed by fines. I suggest you read the welcome packet very carefully. We take our community standards seriously here. She turned on her heel, her sensible pumps making precise, authoritarian clicks on the pavement as she marched away. We stood there in silence for a long moment, the iced tea in our hands forgotten. Elena looked at me, her brow furrowed. Are you kidding me? A whimsical or folkloric effigy. I picked up the gnome, its cheerful, painted smile now seeming almost defiant. Welcome to the neighborhood, I muttered, an old reflex surfacing. Objection, Your Honor. The prosecution is being ridiculous. The old words felt alien on my tongue. I had left the courtroom behind, but it seemed I had just walked straight into a different kind of docket, one presided over by Judge Carol Peterson and her tribunal of one. And as I looked at her, retreating, ramrod straight back, I had the sinking feeling that this was only the opening argument. The first letter arrived 2 days later, delivered by hand, and tucked neatly under our doormat. It was on thick, cream-colored letterhead, bearing the Maple Creek Estates HOA logo, an elegant, stylized maple leaf that now seemed vaguely menacing. The subject line was in bold, unforgiving letters. First official notice of violation bylaw, 17C4. She actually did it, Elena said, reading over my shoulder at the kitchen island. Her voice was a low hum of indignation. We had, of course, removed the gnome. It now sat on a bookshelf in my study, its painted-on fishing line dangling over a row of leather-bound legal texts containing the complete federal rules of civil procedure. We had complied. But the letter was dated the day of our initial conversation with Carol. It detailed our infraction in painstaking detail, noting the time of observation, 5:37 p.m., and the precise nature of the offending object, 1-1 ceramic gnome, approximately 12 inches in height, of folkloric design. The letter stated that while the violation had been cured, this notice would be kept in our permanent file. Subsequent violations of any kind, it warned, will result in immediate financial penalties. She's establishing a paper trail, I said, the phrase clinical and familiar. Establishing a pattern of conduct. It's a classic tactic. I took the letter and went to my study. I didn't just toss it in a drawer. I took out a fresh, accordion-style folder. On the tab, I wrote in neat, block letters, Peterson, C, V, Davies, A, et al. It was an old habit, framing every conflict as a case to be managed. A little dramatic, don't you think? Art, Elena asked from the doorway. You never know when you'll need a well-organized file. I replied, proper documentation is the foundation of any successful argument. For 2 weeks, we were model citizens of Maple Creek. I read the entire 200-page book of covenants, conditions, and restrictions. It was a masterpiece of micromanagement. I found myself unconsciously analyzing its structure, noting the vague definitions and procedural loopholes. This document is a masterclass in ambiguous language. I commented to Elena one night. A good lawyer could drive a truck through these holes. A bad one, like Carol, will just use it as a cudgel. Our first fine came on a Saturday morning. Notice of fine violation of bylaw. 22A1, landscaping substrates. A $50 penalty. I was baffled. It turned out Elena's choice of a rich, dark brown mulch was a violation. Only cedar-based, of a reddish-brown hue, was permitted. The sheer, unadulterated pettiness of it is breathtaking. Elena fumed. It's not about the mulch. Lena, I said, examining the letter. It's about jurisdiction. She's asserting her authority over every square inch of this property. I felt an old, familiar anger begin to simmer. The cold, clear anger of seeing a system being abused. But I tamped it down. Anger is a poor litigator, my love, I said. Another of my old courtroom adages slipping out. The colder you are, the more clearly you think. I spent the afternoon shoveling out Elena's beautiful mulch and replacing it with the garish, HOA-approved red cedar chips. It felt like a tactical retreat. That evening, I went to my study. I photocopied the violation notice and the canceled check for the fine. I took a photograph of the new, reddish-brown mulch. Then, I opened the Peterson v. Davies file. I took out a set of colored tabs. I placed the correspondence behind a blue tab, the financial documents behind a red one, and the photographic evidence behind a yellow one. Organization was paramount. The fines became a regular feature of our lives. A $75 fine for leaving our garage door open for more than 3 hours. Bylaw 11D, aesthetic nuisances. I had been timing myself. It was 3 hours and 20 minutes. A $100 fine for our garden hose being improperly coiled. Bylaw 19F, equipment storage. With each notice, my file grew. I cross-referenced the bylaws, highlighted the relevant text, and wrote short, concise notes in the margins, as if preparing a brief. Note, improperly coiled is not defined within the text. Vague and unenforceable. I scribbled on the hose violation. Elena watched my ritual with a mixture of concern and admiration. You're building a case, aren't you? I'm creating an unimpeachable record, I corrected gently. There's a difference. A case argues. A record simply is. The transition from bureaucratic harassment to something more personal and invasive happened on a Tuesday night. Elena woke me, whispering about a noise in the backyard. I slipped out of bed and peered through the blinds. The motion sensor light was on, and I caught a glimpse of a dark-clad figure melting into the shadows between the houses. Go look at my roses, Elena said, her voice trembling. A knot of dread tightened in my stomach. I grabbed a heavy flashlight and went downstairs. The beam cut through the darkness and landed on her rose bushes. Every single bloom had been meticulously, brutally decapitated, snipped off with shears. The severed heads of the flowers lay scattered on the ground. Elena let out a choked sob. It was her. Circumstantial, I murmured automatically, my mind assessing the scene. No direct evidence, no witnesses. He said, she said. It wouldn't survive a motion to dismiss. Art, "This isn't a courtroom," she cried. "She destroyed my garden." "I'm calling the police," I said, my voice a low growl. The judicial calm was cracking. "And say what?" she countered, her logic sharp, despite her distress. "That we suspect the HOA president of being a midnight rose beheader? They'll think we're crazy. It's her word against ours." She was right. It was inadmissible hearsay. Speculative. We had nothing, and showing our hand now would be a strategic error. "Okay," I said, my fury solidifying into cold resolve. "New plan. We need to establish our own surveillance. We need admissible evidence." The next day, I began my research. I wasn't just looking for cameras. I was looking for a system that would provide evidence that could withstand legal scrutiny. I delved into technical specifications, muttering to myself about establishing an unbroken chain of custody for the digital files, and ensuring the timestamps are server-verified and tamper-proof. I chose a wired PoE system to prevent wireless jamming, with cameras that had a high dynamic range for clear nighttime recording. I spent the weekend installing it myself, running cables through the hot attic. I placed the discrete dome cameras meticulously, ensuring they covered every inch of our property, but not a single inch of our neighbors. I was keenly aware of privacy laws and the potential for a defense attorney to claim illegal surveillance. My cameras would only see what any member of the public could see from the street or an adjoining property. When the high-definition feeds flickered to life on a dedicated monitor in my study, I felt a grim sense of satisfaction. The record would now have a visual component. A few weeks passed. The fines continued, but the vandalism stopped. Then came the lawn. We woke up to a perfect, brown circle of dead grass near the sidewalk, the air thick with the smell of herbicide. It was a deliberate, public scar. I went straight to the NVR. The footage from 2:15 a.m. showed a figure in a dark hoodie and face mask. Deniable. But as I scrubbed through the video frame by frame, I saw a sleeve rode up, and a distinctive, glittering tennis bracelet glinted on a wrist for less than a second. I'd seen that bracelet on Carol Peterson's wrist just days before. I isolated the clip and saved it to a secure, encrypted drive, creating 2 backups. It wasn't conclusive proof for a criminal court, but in a civil case, under the preponderance of the evidence standard, it was compelling. I logged it in my file Video Exhibit 1A, Lawn Vandalism, the case of Peterson v. Davies was growing stronger. Having been stymied by my cameras, Carol shifted her strategy to the Court of Public Opinion, the official Maple Creek Estates community Facebook group. Her campaign of social isolation and slander was executed with tactical precision. It began with passive-aggressive posts about newer residents who didn't respect community standards. I recognized the technique poisoning the jury pool. I didn't engage. I simply began a new evidence category in my file, tabbed in green for digital and social media. I used a web archiving tool to create perfect, time-stamped copies of the pages, preserving all metadata. The attacks escalated. A post appeared from Carol, deeply concerned about reports of aggressive and unstable behavior. "I have received complaints about shouting matches and profane language." It was pure fabrication, libelous on its face. In the comments, when asked for details, she replied coyly, "I can't name names, but I suggest everyone be cautious around the new residents on Willow Lane." We lived on Willow Lane. We were the only new residents. The social chilling effect was immediate. Neighbors averted their gaze. The friendly waves stopped. We were ostracized, declared guilty without a trial. The final blow was the digital invitation to the annual block party, which included the line, The HOA board reserves the right to restrict attendance to ensure a pleasant time for all. We were not invited. Elena was heartbroken. She's turning everyone against us with lies. It's not just lies. Lena, I explained, my voice cold and precise as I archived the latest post. It's defamation per se. The statements are demonstrably false and are intended to cause harm to our reputation. The burden of proof would be on her to prove we actually did those things, which she cannot do. Each post is another nail. That evening, I called Marcus Thorne, one of the sharpest appellate lawyers I'd ever known. "Art, I thought you'd be off the grid by now," he boomed. "Just a different kind of wilderness." "Marcus," I said. I didn't frame my problem as a hypothetical. I had moved beyond that. "Marcus, I'm building a civil case, acting pro se for now. I want to run the prima facie elements by you for harassment, defamation per se, and intentional infliction of emotional distress based on a pattern of conduct by an HOA president." I spent the next 20 minutes laying out the facts, citing the specific fines, the documented vandalism, and the archived social media posts. I spoke like I was dictating a summary judgment motion. There was a long whistle on the other end of the line. "Art," Marcus said, his voice serious. "You're not building a case. You've built a fortress. This is an absolute slam dunk. The evidence is pristine. Her malice is practically a co-defendant. You could sue her into the next century." "That's my reading of it as well," I said calmly. "Just wanted a second opinion before proceeding." "So, what's the next step? Want me to draft a demand letter that'll make her hair curl?" I looked at the thick file on my desk. A demand letter was a warning shot. Carol Peterson was not the type to heed warnings. She was the type to double down, to escalate until she had exhausted all her options. "No," I said, "not yet. I believe she has one more escalation left in her. She's going to try to use a higher authority. Let's let her. I want to give her all the rope she needs." Marcus chuckled. "You always did enjoy letting the opposition build your case for you. Judge, just let me know when you're ready to let the jury see the gallows they've built for themselves." We hung up. The phase of evidence gathering was nearly complete. All that remained was for the defendant to overplay her hand in a final, spectacular fashion. And I was certain she would. Carol's next move was exactly as I had anticipated. She sought to legitimize her personal vendetta by weaponizing legitimate municipal authorities. She was attempting to use the state as her cudgel. The first official visitor was a man from the City Code Enforcement Department, responding to an anonymous complaint about an unpermitted structure in our backyard, Elena's beautiful, handcrafted cedar pergola. I met the inspector at the door. "Good morning," I said pleasantly. "Arthur Davies. Before we proceed, per City Ordinance 4.17b, could I see your identification and the complaint number for my records?" The inspector, a burly man named Henderson, according to his badge, blinked in surprise. Most people weren't familiar with the procedural codes governing his job. He showed me his ID, and I jotted down his name and the complaint number. "Of course. Please, come through." I led him to the backyard. He eyed the pergola. "This is the structure in question. The complaint alleged a hastily constructed, unsafe lean-to." "An interesting characterization," I said dryly, "and one that is demonstrably false." I excused myself and returned from my study not with just the permit, but with a neatly organized folder. Here you will find the original permit application, the stamped and approved architectural drawings, the receipt for the permit fee, the certificate of inspection for the concrete footings, and the final certificate of occupancy issued by your own department last month. I trust you'll find everything is in order." Inspector Henderson's jaw tightened as he flipped through the documents. He was a professional being used as a pawn in a petty squabble. "Everything is perfect, sir," he said, handing the folder back. "I'm sorry to have wasted your time." "You haven't wasted my time at all, Inspector," I said smoothly. "You've provided valuable, third-party corroboration of a pattern of harassment. I will be requesting a copy of your official report stating that this complaint was baseless. I may need to call you as a witness in a future proceeding, so I'm grateful for your thoroughness." The inspector's eyes widened slightly. This was not the conversation he was used to having. "Yes, sir," he said, his tone now one of deference. "I'll be sure my report is very detailed." 2 weeks later, Animal Control arrived, responding to a report of a neglected, whining dog. We don't own a dog. I went through the same calm, methodical process, documenting the officers' names and the incident number, and politely informing them that their report would form part of a larger legal file regarding malicious and fraudulent complaints. That evening, Elena looked at me across the dinner table. "You're enjoying this, aren't you?" In a strange way. I considered her question. "Enjoy is the wrong word," I replied. "But there is a certain professional satisfaction. She thinks she's using the system against us, but she doesn't understand it. The system has rules, procedures, checks and balances. It's a complex machine. She's just banging on the outside of it with a hammer. I'm inside, and I happen to have the operator's manual." The final escalation, the one that moved her actions from civil tort to potential felony, came on a crisp autumn afternoon. I was raking leaves when Carol marched across the street, her face a mask of triumph. "Davies," she said, her voice sharp, "I know all about you. I made some calls. The Barrett Prettyman Courthouse. The United States Federal Judiciary." She spat the words. "You're some kind of government paper pusher, a clerk, an administrator." The relief was immense. She was so close, yet so profoundly wrong. "You think you're so smart," she hissed, stepping closer. "But it would be a terrible shame if someone were to contact the Office of Personnel Management. I bet they wouldn't be happy to hear that one of their former drones is a public nuisance. It could cause all sorts of problems for your pension. A federal pension is a fragile thing. I hear." And there it was. In my mind, a switch flipped. A cold, quiet clarity descended. This was no longer a neighborhood dispute. This was now a federal matter. My internal monologue was no longer that of a frustrated homeowner, but of a judge reviewing a criminal statute. 18 U.S. Code Prov. 115. Influencing, impeding, or retaliating against a federal official. She has just made a direct threat against my person and livelihood, linking it to my prior service as an officer of the court. She has no idea what she's done. I looked at her, and the affable retiree vanished. She was looking at something else, something hard and unyielding. "Carol," I said, my voice so quiet it was almost a whisper. "You have just made a grave error in judgment. You have mistaken patience for weakness. You have no idea of the forces you are attempting to manipulate, or the laws you have just broken." I turned my back on her and walked into the house. I went to my study, sat at my desk, and placed my hand on the thick file labeled Peterson v. Davies. The time for documentation was over. The time for adjudication was about to begin. The final demand letter was the trigger. It arrived via certified mail, A document totaling a fraudulent $3,500 in fines and fees, threatening a lien on our property within 7 business days. This was her checkmate. We're not paying it, I told a pale-faced Elena. In fact, we're going to ignore it. Let her file the lien. Let her create one last piece of official documentation of her own malfeasance. The deadline was a Friday. That afternoon, Elena and I were in the front yard, a picture of serene domesticity. At precisely 4:15 p.m., Carol's Lexus screeched to a halt. She stormed across the street, her husband Bob trailing nervously behind her, the entire neighborhood watching. "Davies," she shrieked, "your time is up. I'm putting a lien on this house." I rose slowly from my knees. "The only thing happening today, Carol," I said, my voice calm, but carrying an unmistakable weight of finality, "is that this ends." Her face contorted in rage. "That's it. You are harassing me. I am calling the police." She dialed 911 on speakerphone, putting on a theatrical, terrified performance, claiming we were threatening her. It was the moment I had been waiting for. Within 5 minutes, 2 police cruisers arrived, a young rookie and a seasoned veteran. A man in his late 50s with tired eyes and a thick mustache stepped out. Carol rushed towards them, playing the victim. The veteran officer held up a hand, his gaze passing over her, then Elena, and then settling on me. His eyes widened. The color drained from his face. His posture snapped to attention. He squinted, his head tilting. "Judge. Davies," he stammered. The word judge, a choked whisper. "Your Honor is that really you?" The rookie stared at his partner. Carol froze, her mouth hanging open. The assembled neighbors began to murmur. I gave the officer a small, weary smile. I remembered him. He'd been a bailiff in my courtroom for nearly a decade. "Officer Miller," I said, my voice clear and steady. "It's good to see you. I'm retired now. Just Arthur Davies." "Your Honor," he said, shaking his head in disbelief. "What on earth is going on here? You live here?" "I'm trying to," I said. I gestured towards Carol, who looked as if she'd been turned to stone. "Unfortunately, Mrs. Peterson has been engaged in a malicious campaign of harassment against my wife and me. Today, it has culminated in this." I held up the extortionate demand letter, followed by her filing a knowingly false police report, a crime I'm sure you're familiar with. "He's lying," Carol sputtered. "I'm the victim." Officer Miller turned his gaze on her, and it was glacial. He knew my reputation for methodical precision. "Ma'am," he said, his voice dangerously low, "you called 911 and reported a threat from a retired United States federal judge. Do you have any idea how much trouble you are in?" "But he's just some clerk," she stammered. I went into my house and returned with the file. I handed the thick, meticulously organized binder to Officer Miller. "You'll find everything you need in here." "Officer," I said, "it's structured like a prosecutorial memo. You'll find tabbed sections for each potential count: harassment, vandalism, defamation, and potential federal violations under 18 U.S. Code. The video evidence is cataloged. The official municipal reports are included, and my own sworn affidavit is at the back. It's a complete record." I paused and looked directly at Carol, whose face was a dead, ashen white. The dots were finally connecting in her mind. All my strange habits, the formal language, the obsessive documentation, the calm under pressure, it all suddenly made a terrifying kind of sense to her. "It appears, Mrs. Peterson," I said, my voice resonating with the quiet authority of my old life. "That court is now in session." The aftermath was swift and decisive. Officer Miller, holding the thick binder of evidence, radioed for a supervisor. The investigation that followed was brief and brutally efficient. Faced with an airtight case, the district attorney's office charged Carol Peterson with filing a false police report and pursued additional charges related to witness intimidation. Simultaneously, Marcus Thorne filed the civil suit. He later told me the opposing counsel called him, after receiving the discovery package, a perfect copy of my file, and said, "This isn't a lawsuit. It's a signed confession. What are your client's terms?" The HOA board, facing personal liability, immediately caved. Carol was removed from her position by a unanimous vote at an emergency community meeting, where a dozen other residents finally felt empowered to share their own stories of her abuse. The settlement was ironclad. Carol issued a public, written apology. She paid a significant sum in damages, which we donated to a legal aid society. She was forced to pay for the complete restoration of our property. And, most satisfyingly, she was subject to a permanent injunction barring her from ever serving on any HOA board in the state again. Stripped of the only power she had ever known, she and her husband sold their house at a loss and vanished from Maple Creek. A new, reasonable board was elected. The absurd bylaws were systematically dismantled. Peace, genuine and unforced, settled over the neighborhood. Months later, Elena and I were sitting on our pergola. The scent of her new, thriving roses filled the air. The gnome stood proudly amongst them, a silent, whimsical sentinel. "Do you ever miss it?" she asked softly. "The gavel, the robe." I looked out at our quiet, peaceful street. "I don't miss the courtroom," I said, "but I've learned that you can take the man off the bench. But you can't take the bench out of the man." I smiled, taking her hand. "And sometimes, that's exactly what's needed to get a little peace and quiet."